Definitely outsourcing enforcement to other countries, to Europe primarily, and how ironic and, in a sense, shameful that the United States, which really originated the idea of antitrust enforcement, trust busting, and so forth, should be behind Europe. And just to sort of add a footnote to what Senator Klobuchar has just said, the way I view your testimony, Professor Rose, is that you're saying not so much that economics have changed or that the economy has changed, but the old assumptions, which were not based on facts, they were theoretical, Bork being, Professor Bork, I should say, with all due respect. I took his course at the Yale Law School in antitrust, simply kind of erected this construct of theory that really bore very little relationship to the facts of how vertical mergers don't have those efficiencies that were presumed and do have the anti-competitive effects that were presumed not to exist, and maybe now we're just becoming more realistic about it. But let me ask you, coming back to remedies, because for many years I was an enforcer, so I'm more interested in the practical results of enforcement. Should we, and this is really a question for all of you, should we be engaging in consent decrees anymore? Shouldn't we just say, no, this is not going forward? This merger has too many problems. We're not going to try to set conditions or divestiture requirements. Just, it's too big.
So I do think we need to have the resources to bring more enforcement challenges, just outright challenges. I don't, unfortunately, think that the option of taking settlement entirely off the table is likely to succeed in the way that we want. I've been increasingly thinking, what congressional intervention could help. And one of the things we're seeing, I think, in the last few years is an increasing tendency of parties to come in having proposed a remedy. I think that Macon had to deal with this when he was at the DOJ as well, but I just see it even coming in more frequently, particularly in the vertical space, but not just vertical. And the agencies are having to litigate the fix, and it's extraordinarily difficult. And so I'm wondering if something like, and I think this would have to be congressional action, a presumption or a burden shifting or a presumption that says, the agencies litigate the merger is presented and the harm, and if the parties have a fix for it, then it's their burden to demonstrate that that will alleviate all of the competitive harm. And they've got the information and data to be able to present that case. It's very hard for the agencies to prove the negative of that because they don't have as much access to information and understanding of markets. And I don't know if that would help, and also at the same time make it a little bit less attractive for companies to come in and say, yeah, we know there's a problem, but let's just settle. But I do think in the vertical context, these conduct remedies just, I'm going to go take your assignment and go back and look, but I'm sure there are some that have worked okay because probably the incentive to foreclose rivals wasn't so strong. But if the companies can make more money by doing A prime, B prime, and C prime, they will say, I agree not to do A, B, or C. That's in the contractual terms of the consent decree. And the Department of Justice is not going to be able to go and convince a judge that, they're doing A prime, B prime, C prime, you should stop them. The judge will say, well, if you didn't want them to do that, you should have written it in the consent decree. And I just think that's the problem we're facing in so many of these situations.
I think, Senator, it depends on, when you say to disallow the consent decree, depends on what do we mean? Is it behavioral or structural? A lot of times a consent decree is a settlement to a merger, where the parties agree to sell something or do something where it removes the disincentive to act in a profit-maximizing way. And that becomes the problem with some of the behavioral remedies that I think the agencies were too quick to enter into. So I think it's, we shouldn't remove them. We should look at what are ways to have them enforceable, to have them that actually solve the problem. The other thing is, we did this for the first time, but Attorney General Reno put in place, Congress 1995 passed a law to arbitrate administrative cases. Attorney General Reno issued regulations. We did that in one merger case for the first time in history. It created efficiencies of resources. It created predictability. The division actually prevailed in that case against my current law firm now. It was a good result. And I think the agencies, and if Congress supported that, is to encourage more of that. Now you have an expert arbitrator that the two sides would agree, who has an economics background, who has an actual incentive to be there, rather than a judge with 400, 500 cases who has no interest to hear this case or want to be, educated by, Professor Rose on one side, but maybe Professor Carlton on the other side, who are both incredibly qualified, but say the exact opposite thing. And that's one of the challenges of administratability. The other thing that I think would be helpful is that we really don't have a lot of judicial guidance on remedies. That's something that I've been thinking a lot about, researching. The Supreme Court's decision in the NCAA last year, Justice Gorsuch's decision, gave some guidance to say, here's the discretion that the judge has, and wide discretion at the district court level to construct remedies. The previous judicial guidance on this was really the Microsoft case in the DC Circuit 20 years ago. About, this was a structural remedy that the judge had imposed, and the D.C. Circuit said, no, not really.
I'm very familiar with
the
case, having actually been a plaintiff
in that matter.
Said to the judge, this structural remedy ain't going to fly with the D.C. Circuit, and we were right, but the district court judge had
Judge Jackson at the time.
Yes.
Yeah, that's the challenge, is that what is the guidance that judges have to craft a remedy, and deducing from that, what do the enforcers have? Because ultimately, that's how do you craft these? It's an administrative issue, and these have nothing to do with, I don't think, Bork judges or Trump judges and all that. The recent case, the Assa Abloy case, was a Biden-appointed judge. The United Health Change, those both remedies that were readily available, the department had rejected, but the judges had rejected.
All right.
My time has expired, so I'm going to ask Ms. Slayman to respond in writing, if you don't mind. I would be very eager to have your response. And again, to all of you, if you have suggestions for consent decrees that have worked, I'd be very interested in getting into them and seeing why they've worked as opposed to the many that have not. Thank you.
Good point. Thank